No, you can say there. Okay, Yama again. Thanks for joining us. We have a big audience online as well because we're live streaming this. So I think we've got over 100 people registered, which is fantastic to participate in what is a very important narrative and dialogue. Can I begin by again acknowledging country and thanking you again, Auntie Jill, for your welcome to country earlier this morning. And I pay respects to Yagara people, your people, and elders past and present. So today it's my delight to welcome Les Malezer to our university. Les shared with me a bio which is extremely impressive, but I won't go through all of it. His achievements are quite extraordinary. Les is from the Gubbi Gubbi Bachelor peoples of the Mary River and Fraser Island region of southeast Queensland on his father's side. On his mother's side, Gamilaroi, my mob, northwest New South Wales, and I welcome my countrymen. Les has devoted his entire career fighting for rights of Aboriginal and Torres Strait Islander people. And that fight has been pretty much a 50-year journey. I hope you had a childhood before you. yeah, good one. So his notable achievement in life is when he addressed the UN General Assembly in 2007 to welcome the adoption of the United Nations Declaration on the Rights of Indigenous Peoples. The following year, in 2008, he was awarded the Australian Human Rights Medal by the Australian Human Rights Commission. Les's career commenced in 1972 as a public servant with the Commonwealth Government. He went on to lead a number of community control organisations at local, regional, national and international levels and held important posts in representative Aboriginal and Torres Strait Islander organisation. He has been and currently remains, he's been for a long time, the chairperson of the Foundation for Aboriginal and Islander Research Action and has held a number of positions since 74. He became Director General of the National Aboriginal Conference in 1984, joined the Royal Commission into Aboriginal Deaths in Custody in 1989, and was appointed as Executive Assistant to the Chairman of ATSIC in 2002. More recently, before retirement, he was co-chair for the first 2 terms of the National Congress of Australia's First Peoples. In addition to all of that, if that weren't enough, he of course was Australia's representative on the United Nations Permanent Forum for Indigenous Peoples. So we're absolutely delighted to have Les join us today. He will be talking on the topic, very timely, obviously, on the United Nations Declaration on the Rights of Indigenous Peoples and reflecting on that in the context of current discourse and around voice, treaty and more recent events in First Nations affairs. So he'll be talking about 15 years since Australia adopted the United Nations Declaration on the Rights of Indigenous People, what's changed, what hasn't, and what's next. Can you join me in welcoming Les Malezer?
Thanks, Tony. Thank you very much for that introduction. And as I said, that's pretty much my lecture now, that's done. So, but as I think has been shown there, there's quite a lot of stepping I think I've been doing, all in the name of human rights, right up to the international level, to as high a level as I believe I could have reached. And then since 15 years ago, my focus is very much turned back to Australia, during which time, the last 15 years, I think it's been a very difficult period, a little bit of which I'll touch on it. But on this date, 15 years ago, in 2007, I was standing at the podium of the General Assembly at the United Nations. The vote had just been completed and declared, saying that the Declaration on the Rights of Indigenous Peoples was adopted. It was a nervous vote, and I'll touch a little bit on that. And the atmosphere was euphoric. There was probably somewhere between 500 and 1,000 Indigenous peoples had come to New York to fill the galleries and so on for that particular event. And for those of us who were in the front line advocating on the rights, it had been a nervous position right up to that day. It was actually the last sitting day of the UN General Assembly for that session. They go basically from September to September in a session. The declaration had been put up for their vote and approval in October of 2006, but to our surprise or to our disappointment, it got overturned by a resolution to say we shall delay this until we look at it further and so on. You may be aware it took 23 years of negotiations on the draft to get it to a stage, and even there we had to ask for a consensus. Not everybody had been happy with whatever they were advocating for, and we had to go to a consensus at the Human Rights Council. It was the new body the UN had created to deal with human rights. That was a big event itself, and it was the second item off the agenda of the new council. But from once the council had adopted it, and the president of the council at that time took the view that once a declaration or a human rights standard is adopted by the council, that should be the end of it. It shouldn't have to go to the General Assembly to get further endorsement. So the council itself was advocating very strongly that the declaration was already adopted by them. So later in that year, that was June. So in October, it went up to the third committee of the General Assembly, where they decided to hold up and to look further into the declaration with the idea of making further changes to it, which of course was as I said, it took 23 years to get that consensus to settle. And all of a sudden the states wanted to change it again. Of course, Indigenous peoples completely were annoyed and opposed to what had happened. But I spent basically the full year from then to September the 13th in New York, lobbying around the different, embassies to lobby support and so on, that there were certain problems and so on that were popping up. There was a lot of misinformation being generated by Australia, New Zealand, Canada, and the US, where they're saying this declaration is all wrong in international law, it shouldn't apply, there shouldn't be a right of self-determination, land rights collective rights shouldn't be able to override the rights of individuals, was a big one they put on the land rights argument and so on. But they lobbied so heavily, and this is unusual in the UN, that Canada was getting its diplomats around the world in the different countries to approach the governments and run the case as to why they should not be supporting the declaration. Well, we all know well, let's go back to the 13th of September 2007. Everyone was assembled. We'd had assurances coming from the states, they were operating in their groups, in their blocks. We had assurances that the numbers were there and the declaration would get up, but it had to go to the vote. Canada immediately called for it to go to the vote rather than just consensus, where there's no objection raised and it goes through. And Canada, I think, called for the vote, and they put up this big screen with 193, I think at the time, states with green and red dots as to whether they vote yes or no, and they had buttons at their table. So everyone was there, and they called for the people to start casting their votes, and the board started lighting up. And it lighted up green, some reds, more green, some reds, overwhelmingly green, which was excellent, which basically got a roar from the galleries, from all the Indigenous peoples around there, stood up clapped, shouted, and did all things like that, which of course you don't make a noise when you're in the General Assembly, but it was a big occasion on the day. And I hope that I can relay to you now the significance and the way it felt on that day when that happened. It was the last event of that sitting, so it started 12 months before the session. They had promised in their resolution that they would conclude this matter before the end of the session. It was the last vote taken in that session before the new General Assembly session started in 1 or 2 weeks' time. So it was very, very significant, very emotional for the Indigenous peoples concerned, and actually a big outcome considering what was going on. It had 4 negative votes from the settler states: Australia, New Zealand, Canada, US. So they, obviously you can see there what the concern was, and let's put it back to Australia. Australia's concern was, do you have land rights imposing over the rights of pastoralists and farmers and miners and all that sort of thing, which is where this argument was about collective human rights should not override individual human rights with the whole thing. So those 4 countries voted against. They were the 4 red dots on the screen. The rest was green. There were some yellows, some abstentions. The abstentions really coming from the small island states like in the Caribbean or even in the Pacific. But it was an overwhelming support for it. It meant that Indigenous peoples delegations had done such a good job over those 23 years to start with nothing, to start with no knowledge or awareness of all of Indigenous peoples, found their way into the UN system to be recognised and acknowledged in the UN system, and then to have significant rights, and particularly here, the rights surrounding self-determination and the rights surrounding land rights, or rights to lands, territories and resources. To have those things come through is a significant change. Of course, when you stand back and look at it, as we would look at it, you would think, well, it's natural. It's natural where this is what human rights are. Indigenous peoples had been dispossessed of their territories, often with, well, almost always, without any idea of rights. They were oppressed by a more dominant society, still lived on the fringes of that dominant society, were living in their, that's my water, living in their territories, associating with their lands and living subsistence living, maintaining their languages. I think 2/3 of the world's languages are held by Indigenous peoples. I understand, looking at some statistics, that 40% of the geographical areas in the world had Indigenous peoples in it, on every continent except for Antarctica. There are Indigenous populations. And as recently come out in the climate change biodiversity issues, really were significant. 80% of the world's biodiversity and the preservation of that. So basically, Indigenous peoples in association with their lands, territories and resources had preserved the biodiversity and lessened the impacts of climate change, but of course are also now the victims suffering from those impacts. So, so it was actually a magnificent achievement for lobbying that. There's a lot of human rights NGOs that lobby in Geneva, where human rights is based. And a lot of them were saying, they had meetings and they were saying, we should lobby like the Indigenous peoples lobbied. We should organise ourselves and do the way they did. Look at what they've done. So we were impressing lawyers and, you know, semi-government based people and so on who were in relatively powerful positions by the fact that we got a unity. We hung on to a unity. And it was that unity that we had we had 7 regions of the world we identified as being Indigenous regions, as against 5 United Nations regions. We had 7, and we kept strictly adhered to that right through all of the negotiations and text and so on. So the outcome on the 30th September 2007 was really, really significant. And within a few months, Australia had reversed. It was not a signature in a declaration, it's a vote, it's a resolution, and that's the end of it. So it's not like a treaty where people would go to a treaty and put their signature down to say that they are signing the treaty and intend to ratify the treaty. So a declaration is simply a vote. So Australia didn't reverse its vote or didn't sign any papers like that. They simply issued a statement to say, we support the declaration. New Zealand followed soon after. US never had a problem. I think they might have, US never had the problem that Australia, New Zealand and Canada had about it. They could accept it because in the US, they acknowledge what they call internal sovereignty of the Native Americans. And they have, I think, 400 odd Native American tribes registered as being sovereign entities in their own right, which means they have their own laws that they live under, they have their own jurisdictions that they operate on and so on. So, America, the US does already have these things, but not Australia, Canada, New Zealand. Anyway, everyone came to the party afterwards by saying that they supported that outcome and so on. It didn't really matter from Australian point of view. We'd been over there lobbying because we were playing that politics already in Australia. I was saying before we started the lecture about, I'm looking at 50 years in Australia now since December 1972 when the Whitlam government came in and said Aboriginal Affairs is a Commonwealth concern and sought to have it all handed over from the states and territories to the Commonwealth. And I'll talk a little bit more about what that record has been over the 50 years with the whole thing. Now, I had a prepared speech, but it was really like a book, and I feel much more comfortable talking freely about this, and I hope I can keep it a bit more interesting rather than just reading it out. But one of the things that I wanted to do is also touch on the declaration, because in Australia, there's still a lot of ignorance around the declaration. When I came back to Australia after 2007, I immediately campaigned to be a co-chair on the National Congress of Australia's First Peoples, a new body to be representative of our national population. But for the first time, it was the fourth effort for a national representative body. For the first time, it was a body owned and operated by Aboriginal people. So it didn't require government legislation, didn't require government approval, but it did require funds. So the Labor Party signed off $29 million to the National Congress for a period of 3 years. We made it last for about 4.5 years, and then we saw the Minister Macklin not long before the Abbott government took power, and they agreed to put in their budget another $5 million for Congress to keep going. But when the government changed, the Conservative government took that $5 million out of the budget, saying they couldn't afford it. So Congress basically ran down to nothing, got some debtors, and then they moved for the organisation to be cancelled. So I'll bring Congress up because I think Congress is part of the response to the Voice proposal. And I'll bring it up in that context a little bit later on. So I came back and I ran for the elections. I got elected in the inaugural one as a co-chair. And I ran a second term, got as co-chair. In the third term, I didn't campaign, but I still come in second. I could have come in, I think, if I'd have campaigned, but I was retiring age by then. I thought it's time to move on and hand over to somebody else. But anyway, that's a petition was raised against me as co-chair of Congress because I would go talking to the public about rights, human rights, and so on. And I would say to the meetings, we're not here to be an advisory body to government. We are here to promote and protect the rights of Indigenous peoples as in the Constitution. And I had big discussions with my co-directors leading up to all that, and they all were on board, all agreeing that of the 5 purposes that Congress had, that was the first primary purpose. But a petition was raised against me because I was going around telling people we're not there to advise government. And I wasn't saying that. We advise government, of course. Anyone that leads a national representative body is going to be consulting and negotiating with government, whether you advise, whether you negotiate, whether you put demands, you're going to deal with the government, and that will be the future for Australia. We will not have 2 separate states. We'll not have an Israel and Palestine situation in Australia if Aboriginal rights are recognised. We will have a compromise arrangement that is agreed between the peoples of Australia as represented by the state, and the First Peoples or the Indigenous peoples of Australia represented through whatever process there is. Now, that's a bit of a messy one. We might have questions on it later. But the point being there that the future in Australia is going to be an agreed arrangement. And we see some of that starting to take form. It's still very, very early days, but in terms of the treaty discussion about Aboriginal people saying we want to be at the table as sovereign, we want to be equals, we don't want to be told, like in native title, what the government's prepared to give us and what it's not prepared to give us. That's not the negotiation of a treaty, and so on. So it just shows you that we are in a difficult time in this current period, let's say within this decade that we're in, about what Aboriginal and Torres Strait Islander people really want and what they're fighting for, and about what governments are trying to fight for and pursue. And I'll bring that up again when I talk about the 50 years, and particularly focus on the Labor government during 50 years. But like Noel Pearson, I also focus very much on what the Conservatives do. Noel has this view, which I think dictates how he responds on issues, that we'll get nothing unless we can get the Conservatives to agree to it. So Noel's whole strategy, including the voice proposal and so on, is all based upon winning the hearts and minds of the Conservatives, and whatever the Conservatives deliver up, then that's going to be something that will hold through the future. And of course, that has a little bit of a ring of truth to it, because the voice proposal was given to a Conservative government. It was written as a bleeding heart statement to appeal to the naysayers and the ones and so on. There's no threat in there of anything. It's not going to hurt anybody or anything in that process. So when we get to questions later on, or make statements later on about the voice proposal, I'm not opposed to against putting the voice in the Constitution. You can put anything in the Constitution as long as it's positive, not negative. What I'm opposed to is that since 2009, so the last 13 years, we have not talked about anything other than the Constitution of Australia and what's to go in there. And I was involved in the initial negotiations of the expert panel, which was an expert panel from all walks of life, Conservatives, politicians, and civil society advocates and so on, had came up with a particular recommendation, which I do support. So my attitude to the voice is saying, why are we wasting time with this, where we don't know what a deliverable will be, and we'll still have the same political football, regardless of what the Constitution says, as the politics change in the government. And there's no, and that's one of the things people say, no details. There's actually no deliverable. There's nothing saying, well, if you do that, you will get national land rights legislation, or if you do that, you will get the rights of Indigenous peoples into Australian law and so on. It's really saying, so, well, okay, if you let our people advise the federal government, our representatives, then that will lead to negotiations to some yet to be seen outcome. One of the arguments, I rely on evidence in the history of the last 50 years. One of the things I'll throw back on that is that in 1992, when the Keating government was negotiating after the Mabo decision on native title and proposed a social justice package, which is still sitting on the shelf. ATSIC gave a social justice package, which to me looks like a treaty. You can get both sides of the parties to sign on to it. When it was negotiated, there was a position created to be a voice to the Parliament. And that was Mick Dodson as the Aboriginal and Torres Strait Islander Social Justice Commission. And his job was to provide a report once a year to the Parliament on Aboriginal and Torres Strait Islander social justice. And then when the native title thing came forward, they amended the legislation to say he shall also provide a report on native title. And over the years, that has now been merged together into the one report that gets given every year. Now, if a voice to Parliament is going to lead us to tangible changes, then my challenge is to say, tell me tangible change, any tangible change, small or big, that has occurred in the last 30 years, since that position was created. It was an institution created, now part of the Australian Human Rights Commission, where a report goes every year to the Attorney General. I would wonder if many people in the room can tell me what happens to that report once it goes to the Attorney General. Did you see the last report? Did you see the recommendations made? Was there any response to it? Is there anything at all in that? So I'm not convinced that I call it, sorry for the adjectives, a bleeding heart statement to the heart, or from the heart, that doesn't have any deliverables actually will deliver if that example doesn't deliver. If the way Parliament can deal with significant reports, like the Aboriginal Torres Strait Islander Social Justice Commissioner, who's responsible for monitoring native title, responsible for negotiating social justice, isn't even on our plates. It doesn't even get our attention, doesn't get any discussion in the Parliament. By the way, those reports and all human rights reports that come, including the international ones on Australia's performance under the human rights treaties, the 7 treaties Australia has signed, do not get any airing at all. They just simply get presented by the Human Rights Commission to the Attorney General, who will wait 2 months and then stand up and make a 20-minute speech, say, I table these reports and sit down. I'll follow up on that just so everyone doesn't just feel frustrated or doubt my point, is that one of the things I'm advocating under a Labor government now is that the Joint Parliamentary Committee on Human Rights, which sometimes get the tag of being a toothless tiger because it can't change legislation or bills, but is there to monitor legislation and bills to see that Australia is complying with its international human rights obligations, that they now give it the ability to call public hearings on reports that are received on Australia's human rights obligations. If it comes from the Committee on Elimination of Race Discrimination or on the Covenant on Social and Economic, Social and Cultural Rights or Civil and Political Rights, that when they come to Australia, and this happens, I believe, it's a long time since I've been to the UK to look at it, but they have a Parliamentary Committee on Human Rights who receive these reports, who look at the reports and recommendations, hold public hearings, get reports from the public, and then formulate the report to the Parliament, including, I presume, ways in which the Parliament should respond to it. Why don't we have that in Australia? You know, and it's a simple thing to me as saying, well, if these reports are being done and they're by and large being ignored by the Parliament, why not make it, put it into a process of where the public get to see, the public get to respond, where there's some attitude or response or proposals being put to the Parliament to consider, and it gets a debate in Parliament in that process. So there's a very simple remedy there that doesn't hurt anybody, except maybe the people who've got to do the work on the Secretariat for this Parliamentary Joint Committee, to make these reports accountable. Now, in here, I talk about how I got to be involved in this campaign for the Declaration of Rights of Indigenous Peoples. I got involved right from when I was 20 years old because I was interested in the land rights movement, and we formed our organisation, the Foundation for Aboriginal Island Research Action, and we joined in with the North Queensland Land Council to fight for land rights. So they took care of North Queensland, we took care of South Queensland, and we became basically the equivalent of land councils for the state and so on. And we joined up then with the National Federation of Land Councils, which was being chaired by Pat Dodson, who at the time was the CEO of the Central Land Council, and was calling for representation from all the states and territories about land rights, because the Hawke government in 1983 promised national land rights legislation and a compact. So the compact one was still being argued. Why does he use that word, not treaty? But put that aside. But the national land rights legislation was promised. And I was part of that committee that was formed at the Canberra level to draft proposals. But we were told by the Minister, Clyde Holding, before we challenge national land rights legislation, let's try the heritage protection. And so we drafted that and we managed to get that through the Parliament under the Interim Heritage Act of Aboriginal Heritage Act of 1984. That continued on. A few years later, they made amendments to take the word interim out of it and made it the Heritage Act. And nowadays, it is nothing but wrapping paper on the floor, because what that did at the time was that if anybody had concern about damage to a sacred cultural area, all they had to do was pick up a phone to the Minister, and the Minister could, just by that phone call, invoke a temporary protection order to stop any further work being done on the site. Nowadays, You can't get to the minister. You can't get a temporary order. You can't even get, go through the courts and get orders for protection because the government, the Howard government in particular, devolved all these responsibilities back to the states and territories, right? So heritage, if you want to protect heritage in Queensland, you start with the Queensland government. If the Queensland government doesn't do the right thing, which we're used to them not doing the right thing, if you try and take it to the federal one, they say, no, you only get one go. If you go to the state first, you can't come to the federal. That's what happened to people down in Tasmania with a significant site they had there on the Jordan River, I think it was called. So that was the first thing, to try this legislation out, see what the temperature at the Parliament was and so on, and it got through. Admittedly, we lobbied the Liberal Party to say, don't vote against this legislation, let it go through, and that's what happened. They let it go through. They could have, I think, made the numbers a bit tricky if they had not supported it. At the time, I think the minister was either Cheney or Bohm, so we had basically a wet Liberal or someone who at least had a good attitude towards protection of rights. So the next task became the National Land Rights legislation. Now, we know that in the Northern Territory, in 1976, I think it is, the Northern Territory Land Rights Act had been adopted. It had been drafted by the Whitlam government. The Whitlam government had disappeared from 1975, but Malcolm Fraser made it a personal challenge to get that legislation through in the Northern Territory, and he did a good job on it. And it's probably the most powerful legislation in the world in relation to the requirements of prior informed consent. So the councils themselves are compelled by the legislation to consult with people, with the traditional owners and so on, to get a decision made about whether to allow mining or a road to go through and so on. But it's there in legislation. But the other thing about the legislation is it meets 5 principles that had been set down for national land rights. And these were the same principles that we were going to try and get in the federal legislation. Now, I usually only get 4 of them, but I'll try and get them. One is inalienable freehold title. Another one is protection of sacred sites. Another one is control over mining. Another one is compensation for lands lost. And again, I'll get up to the 5th one, so it's probably something around there. But the principles are the same principles that appear in another international document, and this one is a treaty called ILO Convention number 169. So ILO Convention number 169 was adopted in 1989 at the federal level by governments, businesses and unions. So it is an international treaty. I think it's got around 22 signatures to the treaty. Most of those are in South America and some are in Africa, and some of the Nordics have signed it as well. But Australia has never ever entertained a look at the ILO Convention number 169. At the time, our delegates from Aboriginal and Torres Strait community and other Indigenous peoples turned their back on the convention in 1989 because when it came to self-determination, there's a clause in there saying self-determination implies no legal rights whatsoever, or has no legal implications. So, and that's the reason they turned their back on it. If there's no self-determination, they're not having to do with it. That's no longer a problem since 2007 because self-determination is verified in the UN Declaration on the Rights of Indigenous Peoples. It's basically entrenched in human rights normative law now in that process. So we would support, I'm saying we and me and whoever else I can convince, we would support Australia ratifying ILO Convention number 169. And just that simple act of ratifying that and putting it into effect puts it into the Australian jurisprudence, and it allows justiciable actions to be taken. And the principles that I talked about of land rights are embodied in that declaration, right? They're in there. So we don't have to go through changing constitutions, which is not easy. If you haven't worked it out, it's not easy to do. All we have to do is convince a parliament to ratify. We might have to convince all the parliaments because John Howard insisted that any international treaties also be endorsed by all the states and territories. Good luck with that one. But nevertheless, the federal government does have the power to ratify ILO Convention 169, and that's been there for how long? 33 years now. And no one's even raised a voice about it all. Now, I lost track of where I was going with that one, but basically I'm saying that those 5 principles of land rights are exactly what we started with in the discussions in 1984 to get national land rights legislation. But recently, when Mick Gooder was Aboriginal Social Justice Commissioner, he held an inquiry into Aboriginal land title in Australia and whether property rights could be exercised from those titles. I think it came up with 30 odd different forms of Aboriginal title to land in Australia. And that's the first problem we saw. Why is there this variety of title, none of which is clear and none of which, or most of which doesn't infer property rights, and so on. And the answer basically is that Aboriginal land should be inalienable freehold title. Now, the underlying title of property, of land in Australia is Crown title, of course. So if you remove all the other things, even native title, Crown title still exists below it. Ron Caston, when he was doing the native title work for us, tried to get a case going to show that the underlying title can be Aboriginal title to land. That hasn't succeeded. He recommended not to try it with the High Court because the High Court got bashed around the ears so much over the Mabo decision about let the parliamentarians make the law, don't let judges make law, which has a reverse ring for us because what we want is fair law, not political law and the whole thing. And when you think about colonisation and the loss of rights to Aboriginal and Torres Strait Islander people, then political law is not going to do it for us. So anyway, our first problem is the number of different titles there are, but the second problem is that there's not very much land in the eastern states of Queensland, the 4 eastern states, the most populous states. There's not much title. Most of the volume of land they talk about is Northern Territory, which is a lot of under Aboriginal title. Western Australia, which has vast tracts of Crown land, which were Aboriginal reserves. And to some extent, South Australia with the Pitjantjatjara lands or APY lands, and so on. But in the eastern states, if you look at the map, you won't, it's pretty hard. You have to get a very big map to see the bits show up where there's land. And generally where there's a block of land, you can flip a coin as to whether it's just going to be an acre or something like that. It's not like people would expect. And of course, I'm jumping a little bit around here, but in the Wick decision of 1996, was it, or 98? 96, found that pastoral leases were not exclusive titles and that native title would exist where pastoral leases exist. Now, in Queensland, we should know because a lot of pastoral leases don't even have paper records that they exist, right? A lot of pastoral leases are based on a penny or a pound or something like that. They're just nominal thing. But the people who think they had those titles and think that they're exclusive titles think completely opposite. They think they own all that land when they don't. They only own the immediate, what do you call it, homestead lease area around their house, but the rest of it is they're entitled to graze. And the leases are all different depending on what's on the paper. Some are handwritten on scraps of paper and things like that. But the government, the federal government, and certainly Queensland didn't want to go down that difficult task of trying to find leases to say that that land is not available. They just, John Howard did in his amendments, put in a schedule to say all those lands are removed from native title claims. So the Native Title Act, that was one of the things that happened in the Native Title Act, was just simply to remove that from Aboriginal claims to have continuing connection to that country. So I've done it in a roundabout way, but the message that I was trying to deliver here is that the experience has been over the last 50 years, Whitlam came in and Whitlam was like, you know, a fire truck running through a set of bicycles, taking on national legislation, creating a Department of Aboriginal Affairs, creating a full-time Minister for Aboriginal Affairs, putting in the Racial Discrimination Act, legislating to override the Queensland Black Acts to stop governments from prisoning people on reserves and policing and so on. And of course starting the Northern Territory Land Rights Act as well as creating the councils, Aboriginal Councils and Associations Act, which was deliberately formed to allow Aboriginal people to form their own system of local government. That was the intention of that. It was created because in Queensland, Bjelke Petersen was bombing out every application by an Aboriginal organisation to register as a corporate body, and they couldn't get through. So they created this legislation to allow them to create under that. So instead of that legislation has now become a noose around our necks, where Aboriginal people are expected to incorporate under that legislation, not the Companies Act or cooperatives or associations, and are controlled by a registrar which tells them what rules they should have and can't have and how they should operate, and all being turned into businesses like mining companies and shareholders. So instead of Aboriginal people getting self-government by having cooperative arrangements amongst each other to choose their representatives to be able to function to meet their own needs, instead they've got to operate like a business and got to register their names and have got to be accountable, got to be audited, et cetera, et cetera. So we didn't want that. We didn't want to become shareholders in companies. What we wanted was to be able to govern our own affairs, self-government. Okay, well, I better pull up, but I've talked a lot around, I haven't really targeted what's in the declaration, but I've targeted what you need to know. That is, it's about self-determination, and it has very clear provisions in there say Indigenous peoples have the right to self-determination. Governments are trying to argue, well, that's a different right. That's an internal form of self-determination. And of course, Australia, in the last term of government, have come up with this definition of self-determination is the right to vote. So that's a complete misnomer and a lie with it. But self-determination is being attacked even after it's proven in international human rights laws and norm. There's a lot of things in there saying that Aboriginal people have the right to determine their political status, as well as participate in the life of the state if they so choose, right? Aboriginal or Indigenous peoples have the right to self-government, of course. Indigenous peoples have the right to their own juridical systems. So when you look at this question about what's going on in Queensland communities now with the Liquor Act, where police are lining up and invading the privacy of everyone who goes on and off the islands over searching for bottles of alcohol, that it's all done under the Queensland legal system, which I remember was actually developed from the colonial system and British invasion and the Magna Carta, not from how Aboriginal communities want to live and function as communities, keeping their identity as much as they possibly can. And then the other part is the lands and territories one. I didn't stress it, but for me, it's so important that we accept the definition that self-determination includes the rights to lands, territories and resources. You can't really be self-determining without your own territories. And I'm not talking about own ownership, I'm talking about recognised territories. And that's an essential thing I think the Australian government has got to bite the bullet on, that territories and resources. So we have no right to resources. I think we can gather firewood to burn a fire if we're camping, or we can strip some products off a tree or something if we want it for medicinal or other purposes. But that's the only resources we've got. There's nothing about the iron ore, the gold, coal, and everything else. So lithium, they're collecting, and some new minerals as well, diamonds, and so on. No rights to resources whatsoever. And yet there's a definition of self-determination in the two covenants: civil and political rights, economic, social, cultural rights. Self-determination involves that peoples have the right to derive their wealth from the lands, territories and resources that they have. So those are the critical parts of the declaration. I better pull up because I know some questions will want to come at me, but there's a whole lot of other things there. Some stage I'll hope to get to make comment on further, but it's a big task at the moment to talk about the declaration, and I hope we get home how important that date was in 2007 and how it shouldn't just drop off the calendar in Australia. It should be a flag flying along with the Australian flag. Thanks, Tony.
Yeah, please. Wow. There's an encyclopedia right there. What a tremendous journey you just took us on of rights, frustrations, political contestation, shared experiences of First Peoples across the globe. There's just so much. We'll have to get you back for the second chapter. out of that encyclopedia. I'm going to open it up for questions. Lena's got a microphone, so if you could please use the microphone. Remember, we're joined by an audience live streaming, so they're going to want to hear your question. And if you're happy to answer here, Les, at the microphone, that would be terrific. So
thank you very much. Thanks very much, Les. That was very instructive and very interesting. I've got two questions, and I don't want to hog the floor, but I've got a Commonwealth question and a Queensland question. And the Commonwealth question is, what do you hope will happen during the current term, during the term of the new Commonwealth government? And then my Queensland question is, do you think that the Queensland Human Rights Act, given that it's got property rights and it also has Indigenous cultural rights that are quite comprehensively detailed, do you think that that will be helpful? And if so, how? Thank you.
Yeah, thanks, Nikki. On the, sorry, just have to remind the first one about the Commonwealth one. What was that?
That something interesting will happen, that the current government will take any steps that you'll be happy with?
Well, the answer is obviously yes. I mean, I hit the ground running the previous elections, hoping that Bill Shorten will become the Prime Minister. I already provided to Pat Dodson a list of 10 issues that I felt had required immediate attention and so on. So it was a big disappointment. I don't think I was the only one. Big disappointment when the results came out, and you know, I didn't feel inspired to put those issues to ScoMo, what's his name, Scott Morrison, and so on. In terms of the, but I think this term of Labor is very, very important, because I decided a long time ago, for us to get anything in the Parliament, we need to have a Prime Minister who says my way or the highway. And that we had that with Gough Whitlam, we had that with Malcolm Fraser on the land rights legislation, and we had that with Paul Keating on the Native Title Act and the social justice package. So, and I believe that the current Prime Minister is of the same ilk. There's a question of how embedded he is in the information around Aboriginal affairs. I think he is personally interested and involved, because he's got a brilliant team of Aboriginal Torres Strait Islander parliamentarians there who, like, take Pat Dodson. You know, if I've been around the loop, Pat's been around a couple of times in all of those things that I've been talking about with the whole thing. So my fingers are crossed. I'm hoping. I've sought appointments with 3 different ministers in the federal government, and one of them will happen next week, and then I'm hoping in next month that I'll be able to do the other 2, and to talk about the sorts of things I've touched on here. Things like, one of the things, for example, is National Congress. National Congress is still not deregistered as a company. What would it take for the government to put National Congress back in place with its 10,000 membership, and to be operating as an interim arrangement until the Voice or whatever direction they decide to go in that gets up steam? But at the moment, without a national voice, everything is being run by the governments. The Queensland government and the federal government are appointing people. I think the wrong people. I don't have anything against them, but I think they're appointing the wrong people to talk about what structure should be in place. And for those who've been around somewhere over a few generations, every time we've had a national representative body, we've had 4 of them so far, they've been elected. So how much work do they have to put in to elect their representation? And not only that, but ATSIC had 30 local councils operating and had around 400 elected representatives on the books. What was the problem? You know, I don't really want to answer that, it's rhetorical, but the thing is, what are we designing in a new body that is going to be where the local voices are heard at the Parliament? And I just think that this is so bleeding heart, so intangible, so away from the experiences that we've had, that it's a waste of time. I'm not against it, I won't oppose it, but I'm trying to send a message, different message out there. On the Queensland legislation, I think it's great that Queensland's done what it has done with the Human Rights Act, and particularly that they did mention self-determination in the preamble, although I would have urged them to be more bold. But I am concerned that the reference to Aboriginal and Torres Strait Islander rights is made under the term cultural rights, because that's more, I know people I've been talking with, they'll talk about, oh, They want Aboriginal people to be doing paintings or to sing songs or play the didgeridoo or do welcomes to country and so on. So that's where everyone's mind turns to on cultural rights. Where do they turn to on political rights? You know, where does the mind turn to saying Aboriginal people want political rights? Well, it turns to things like people saying, you know, places in the parliament. You know, Michael Mance has renewed the call that there should be Aboriginal dedicated seats in the federal parliament. I don't think anyone's going to play that game, but the point is that if you're talking about, and what about economic rights? I think one of the speakers at the launch before talked about intergenerational wealth. I think it was Tony. And that's one of the issues that we took to the Lord Mayor a week ago, saying what's he doing in South East Queensland for the Olympic Games in 10 years' time? Shouldn't the target be to see that Aboriginal generational wealth increases? We don't want to see people getting jobs in mining companies or high-paying jobs at the universities or things like that. We want to see the population have more wealth or have wealth, because Aboriginal people don't have wealth. We don't even have property in Brisbane, for God's sake. You know, that we own the building at Farrer, but there's very few organisations that own any property. So my answer then comes back to the idea of reference to cultural rights is good, but there could be more. And this comes to what we were talking about before the lecture started about where does political will stop? You know, where does it, they start to get nervous about the reactions to that. And that's one of the reasons I left the Queensland government in 1994, was over native title and mining. And basically, you know, Aboriginal interests were blocked out of that process.
More questions? Yeah.
Not a question, but more of a comment. I'm Thiru Aravindan. Welcome to, been here 20 years in Toowoomba. And I think what is important is finally recognizing as human beings and the human rights, and where the lands we live and the waters that tell us the story and the traditions that we need to understand. And for me, I'm just started to learn the tip of the iceberg of this native land, and I'll be learning. Thank you very much.
Other questions?
Liz, my name's Trish. That was fantastic. Thank you very much for coming and talking with us today. I have a question that's more about probably you as a person. So when you were talking about being in the UN and in New York and all of those delays, where was your support network? Like, who was with you at the time to be able to give you that support, especially when, as you said, like Australia was voting no and you were there by yourself, or were you there by yourself, or who was that support network for you?
Bottom line is I was there by myself, but there were support networks. By that time, we had very developed email networks, both with myself in Australia and the Pacific region, and also with all the other regions. So any time that I felt there was a need, I would just send out the message, come in for a meeting, we've got decisions to make. So we were able to communicate very effectively. I had some volunteers. Someone donated an office to us right across the road from the UN Plaza, and some volunteers to come in to do stuff like putting information up on a website that we'd started, printing out kits. I didn't realise until I went through this stuff yesterday, how much paperwork we pushed at all the missions and to the lead bodies, lead governments, or what do you call them, lead states in each of the bodies and so on. We had very strong support coming from the South Americans and particularly from the Mexico government. We had the EU strongly supporting us, even though Britain didn't believe in collective rights. But the EU were basically in their own group system suppressing that from being a problem and so on. We had good networks in Africa where a lot of the concern was coming about. In Africa, it's a different situation. I won't go into it. But there were people that were, particularly the Nordics, had good relationships with the Africa Unity and African governments and so on. And so there was a lot of lobbying and networking going on there. So it was that sort of thing of where it was, you know, digital network, I suppose, operating. In terms of money, I supported myself for most of it, but the Tasmanian Aboriginal Centre gave me a job for 3 months from December through to end of February down there, which allowed me to get a bit of income and go back after winter to New York to lobby on things. So, but in my frame of mind, I just said to people when that vote came down in October, that deferred the whole matter. I was saying, we've got to stay here. We've got to lobby. We can't walk away. We've got to be lobbying every day. And so that's essentially what I was doing. And I did have individuals coming in from time to time to work with me and do those sort of lobbies, but it was pretty comfortable in terms of the support that I was getting in that process. Yeah.
One last question. Got time for? Lena, have you ever?
Australian government has done enough to readdress past policies and interventions for First Nations people?
I was waiting for that question. I'm going to plead the fifth. No, I'm joking. I'm joking. Definitely, I think that's everything I'm doing now, like in these months and so on, since the elections, federal elections, has been focusing on how to make hay while the sun shines. And it was very difficult during the Rudd and Gillard years because they didn't do anything apart from Rudd did the apology, the stolen generations, and I think it was the Gillard government that reinstated the Racial Discrimination Act into the Northern Territory intervention. But apart from that, over, what was it, 6 years, 2007 to 2013, sounds about right. It might be a little bit longer than 6 years. Over that period, there was no proposal to do an Aboriginal Affairs. And that's what worries me, which I talked on a little bit before about the voice proposal, because apart from the voice proposal, what are we expecting to happen? You know, what is, we've got all these things like the rates of imprisonment, the criminal age of responsibility. I've mentioned some reforms that I think could be happening, like the Parliamentary Joint Committee on Human Rights, and the national body. The Congress can be reinstated immediately if the government might have to have some political explanations ready as to why it's doing that, but it can be reinstated, which gives it a conduit to, I think, the national campaigning for whatever they want to do. So, but the point is too, and I put my mind to this, there's a risk, there is a risk that Albanese will not win the next term, you know, and I'm not an expert, I follow politics quite a bit, but it is possible that it can turn bad on him, particularly failing to deliver, I think, something that Aboriginal people or other people might have expected to get from this government. I see the politics at the federal level being that we've got this, the Teals, this new group of independents come in, and I think we've also seen the Liberal Party being isolated as a right-wing faction rather than a Liberal Party per se, with the loss of people like Malcolm Turnbull and others in there. So I think at the moment the Liberal Party's got a problem. So one of the political expectations I try to entertain is that perhaps we can marginalise the Liberal Party to a smaller percentage of the population and be recognised as a hard right group. But then I think we have to have the Teals and the Greens, I think, taking up space in that process, because Labor decided quite a while ago to become more middle party on the political line of it all. But at the same time, when it comes to government, that's who people who are left-leaning voters will vote for Labor rather than the Liberals. So I'm hoping that we can see a shift, let's say at the next elections, where it becomes even more movement squeezing up the right Conservatives. But at the same time, a mistake could cost Albanese very quickly, and 3 years is not, you know, they're not going to do much in 3 years. They're already saying, you know, it looks like they're not even going to look at a referendum during 2023, and they wouldn't have it during an election year. So it's a limited space. It's part of the reason as why there should be deliberate action early. Make it early to allow to explain or recover ground during a term. If they start thinking in terms of 2 terms, we're in trouble. I didn't mention that we worked very closely with Kim Beazley when he was leader of the opposition, and we kept on encouraging him because he was ready to support the issues that we wanted to promote. But what he missed 2 or 3 elections, then he retired from it. So that was an opportunity which doesn't come by very often. The answer is you have to have a prime minister who will say my way or the highway. Anthony Albanese might develop into that sort of a prime minister in the process. In fact, I think he's partly like that at the moment, but we don't see much of him, his persona in the public on that sort of thing. I'll just add one other thing, is that I think the problem with the parliament, there is a problem with the parliament, and I've told people it's that deep, dark heart in the parliament. When we put up the report from the expert panel on constitutional change, and we said the tangible benefit will come is if you put in a clause to say parliaments cannot pass racist legislation. And we felt that that would lead to developments, including with the courts having to determine whether legislation is racist or not. But the Conservatives have cottoned onto that. Abbott made it clear, I think in a speech soon afterwards, that he was not going to support anything to prohibit racist laws and so on. And they'll never say it publicly, but they'll say it in their rooms, in the caucus rooms or whatever they have on doing that. So, but I think that is, it was in my speech as one of the 2 things I think that we're trying to achieve through our organisation, is to deal with racism and how it's being handled through Australian jurisdictions and jurisprudence, including the exercise of special measures. I mean, was the Northern Territory intervention a special measures? Well, you'd have to be pretty limited, I think, in your interpretations to think that it was. And it was also, I think, Nikki probably would agree with me on this, is that it was where the human rights of some, which the concern was about domestic violence, which is fair enough, interfere with the rights of others. And it wasn't just people committing domestic violence, it was interfering all the rights of all the people that lived in community were being penalised or treated differently, not equally, for that reason. So the fact that human rights are interdependent, indivisible, and so on, and it should not interfere with the rights of others, is one of the things that is a problem at the moment with the liquor thing, with the Queensland Liquor Act and still the Northern Territory intervention, even the credit card system, what do they call it, the green card or whatever, that someone was complaining, one of the parliamentary members, Liberal senator from South Australia, was protesting about lifting the restrictions with the credit card. But as far as I know, through the Centrelink process, anybody who wants to have payments made through a particular system in a particular way can arrange that with Centrelink. You don't have to apply it to everybody for that to be in effect. So we need different methods, including, I'm jumping a little bit here, including policing in Aboriginal communities. You know, that the one example in Central Australia where the person got shot by the police, was shot and killed, and so on. We don't want policemen in the communities. What we want is a form of building social cohesion, you know, futures, and so on, not this sort of commit a crime, get arrested, pay the fine, hand over your welfare money, and that sort of thing. That's the way the system works, has always worked. It's been going in Queensland since 1897, and it hasn't worked ever. Why are they still running with it? So I'm having my little bit of dig there about special measures and why Parliament shouldn't be allowed to pass racist laws.
Well, unfortunately, time has beat us. thank you so much. I feel that we must meet again and hear further, and perhaps more like a kind of a more interactive, you know, yarning circle or something like that, where we can put these questions to you and have some debate, because I think we're only just starting a really deep and rich conversation. As a university, we're incredibly proud to have not only your experience in sharing with us, but your wisdom, your insights, your passion, and your fight for our people. You get all those qualities from your Gomeroi side. I was just looking,
True.
and the fact that he has an age. Have you seen the photo I sent? Look, he looks exact same.
I actually
And that-
got the tie as well. You'd like to replicate that photo.
Yes, that was back in 07.
Yeah.
Yes, and you had a special birthday the other day.
Sunday.
Yes, on Sunday. So from all of us, many happy returns, and thank you very much. Can you join me in thanking us again? Okay. Thank you. Okay, that's yours.